Meeting to order of the Contracts and Compliance Board. Today is Thursday, December 18. Welcome, everyone. Before we start, I want to welcome our new board member, Emma Boyds Elliott. I hope I said your name right. If you want to introduce yourself.
Sure, everyone. Yeah, happy to be on the board. My council vote was just Tuesday night, so this was a nice surprise to have a meeting right away. Very happy to be here and excited to serve. I'm an attorney in town. I have my own practice. I practiced before that at a firm focusing on affordable housing development, so I'm familiar with contract and construction law and as well as some labor law as well, so looking forward to being of service.
Well, we're happy you're here. Welcome to the group. We are going to go to the next section of the agenda, which is the public comment. Do we have anybody signed up for public comments? No? All right. Not having anybody signed up, I remind the public that is watching that we welcome you to come and talk to us. You basically just need to show up and sign up for comments, so I hope people will take advantage. This board, it's at the service of the community, and we do a better job when we hear from you. Now we're going to go to the next section, which is comments from board members and contacts and disclosures. Anybody wants to? No? Okay. We're in good shape. The next item on the agenda is the reading of the minutes from the last meeting. You have them on your packet if you want to take a minute and check it out. And if you are okay with it, somebody can make a motion to approve or to make any changes.
Motion to approve.
We have a motion. Do we have a second? We have a motion and a second. Any discussion? All in favor say aye. Aye. Oppose? The motion is approved. Thank you. The next item on the agenda is an update from our Executive Director.
Thank you, Mr. Chairman. We do have several information pieces in your packet for this evening to review. Just a quick update on this last 30 days or so. We did complete uploading on our new safety report platform to exist all Metro facilities on our building operations side. Our safety coordinator, Paul Hensley, kind of is saddled with those things. We probably have 85 buildings under general services realm that we'll start doing OSHA 1910 criteria type inspections on, which is again a lot of worker safety and facility safety type criteria is in those checklists. So probably in the next 30, 60 days we'll be able to update some statistics and information on that side of the fence as well. On our current project sites, and the Nashville Youth for Campus for Empowerment, the Juvenile Justice Center, happy to report Bell Construction, last 30 days we have no incidents or accidents on that site. Again, we're pushing almost 300 workers on that site now. The roof's going on, so there's a lot of MEP and infrastructure interior work that's starting. Exterior windows are going in. The new plant operations is getting set this week. And the cottages, if you're familiar with that project, roofs are going on those now too. So there's a lot of workers on site, and we do have another scheduled inspection Tuesday next week with Bell's safety coordinators on site there. So that project's progressing nicely. The Global Mall, Hickory Hollow, again, a lot of demolition work with Tiny's construction down there. We're still gutting the interior portion of that mall and putting finishes on the anchor buildings, if you would, around the outside, because we have different clients, including the Nashville Fire Department, KIPP Academy, and those type facilities are getting closed in. So those are all separate buildings of what used to be Sears and JCPenney, and I'm not even remember some of them. It's been so long. So planning is still saddled with, you know, what we're actually going to do with the middle part of that development. More to come on that next year. But again, lots of demolition and material site haul-off that we're going to use for other projects is going on out there. Again, no accidents in the last 30 days out there. It is a limited crew with 2 subs out there right now doing that work, but they're doing well. Probably schedule a visit with them too Tuesday next week. Happy to report as well. We've got a meeting scheduled with Metro Water as we bring them under our realm on the 6th of January. That one got pushed a little bit again too till after the holidays, but we are scheduled to meet with their legal team and their construction teams to introduce them to our initiatives and bring them into the fold. Schools, Metro Nashville Public Schools, we have reached out, including our legal team, on some 3 or 4 dates for January as well. So as soon as we hear back from them, we should be able to get that meeting set up as well. I know that one's taking a lengthy time with the MOU requirements with that department, but I think we're making some progress there. NDOT, we're still working through getting them under our realm. We have made some introductory meetings with them last month, but there hadn't been any progress since then, but we're still working on them. Complaints and contract issues, currently we don't have any contractual or any safety issues on any of our projects right now. Update from our business assistance office team is pretty much status quo from our information we communicated to you guys last month. They are reviewing 77 contracts. 9 are flagged for some compliance reviews, which they haven't gotten to, 4 of which are our projects under general services now, which includes the Juvenile Justice Center and the Global Mall. They also flagged some completed projects to go back and look at too. Our new police precinct down southeast here on Murfreesboro Road, they're looking at some information on it as well. So as we get some more updates on our next meeting, I'll communicate that to the board. One of the things that we've been working on too, we've talked a little bit in the past, is Hub Nashville. Information that came out of our complaint subcommittee. We are establishing on Hub Nashville our button, if you will, for people to log any issues or complaints or concerns related to our construction projects. I'll forward you guys some screenshots via email here next week. There's a couple more approval processes that's going through with our IT department, but again, you'll be able to go out on our Hub Nashville, click on the Contract and Compliance Board. It's going to take you to a screen that shows the address location. If any of you guys have been on that program, then you can log the information either anonymously or put your address, name, phone number, email information in for follow-up and describe whatever the particular issue is. In your package, about 3 or 4 pages back, you'll see a little snapshot of what that's going to look like. We're actually going to have these business cards made, and some posters probably will be developed that'll have a QR code on them with our address and email. The email will be hubccb@nashville.gov. That'll be a direct email too that'll get forwarded to myself, so we can log that information and follow up on any investigations that anyone might plug in that system. So we're still kind of going through a little test deal right now. They've established the QR code, and as soon as I get that, I'll distribute that to you guys, and we'll get some posters and the business cards made for distribution, and we'll be able to, again, create more awareness for this process and be able to post those items and distribute them on our sites. Board leadership, the 2 biggest things that we need to accomplish tonight too, again, is reviewing the contract safety language that we've drafted and proposed. We have gone through our legal comments and red lines, as well as Ava and Dennis on the procurement and finance side. I know there's still probably some revisions and input from the board that we can discuss tonight, but those next 2 pages that are in the packet of information, some of this is printed on front and back. I have tried to just save some trees and not print so much paper here this past month, so it's front and back on that next 2 sections. And again, going back to summary, we've talked to our contracting, legal, our procurement department. We've consolidated between 2, maybe even 3 contracts. Ava could probably weigh in on a little bit of it, but we've consolidated a couple different paragraphs that are in a couple different areas in our contracts to be complete and concise in one place, if you will, then this language will be added to our construction contracts moving forward. I know there's probably some input and some other parameters that you guys might want to offer and look at, but again, this 4 pages here on that next section is what we're proposing from this board for council recommendations moving forward, and we'll finalize that here with legal, with your all's blessing, to get that in front of them in the right format for council meeting here coming up in January for their review. Part of this language does add our safety platform requirements and outlining a few things with what that looks like with the contractors and sub-tier trades on our sites as well. Moving forward, that language has been added here that's new to Metro, so that's a part of it as well. Next section involving that too is, part of when you get into writing scopes and contract language, you have to define certain terms and things of that nature, right? So part of that on the 3rd page back is the proposed definition of what a construction contract is. Pretty lengthy description there if you guys have had time to read it or look through it. Again, we've kind of vetted this through our legal team with Derek and Matthew and with Dennis and Ava, and I think we pretty much had limited comments and red lines on this. But again, this is part of the contract definition section where we describe, okay, what is a construction contract and what that will include. Pretty straightforward. Again, it's going to include a lot of what we're moving forward with on our other departments like Metro Water and NDOT and public schools will be all encompassing with this particular terminology here with, anything that's going to be infrastructure, demolition, maintenance, moving forward as described here in this. So again, welcome any further comments and revisions for legal review and Dennis's team to review to move forward with those definitions are part of this. We can look at this in detail tonight, but again, these are 2 things that are the big priorities to meet our deadlines for council submittal here in January coming up. Yeah. Part of...
Is it in the agenda to review that contract?
Pretty much under the director updates here, that contract safety language is where all this is talking about with these supporting documents.
What I mean is, are we going to discuss the contract tonight?
Not a total contract per se, but this language that we're proposing to add or we're proposing to submit to council recommendations, yes.
Okay. So should we wait till you are done with your report to?
Yes, we can. The only other thing that I've got to add, other than the Hub Nashville, was basically introducing Eric and Julie with our partnerships, our consultant team here too, that'll lead us later this evening in the KPI portion of the program and the evaluation stuff that's a part of your package as well. But that's all, Chairman.
Thanks. Any questions, comments?
Hey Trey, thank you for putting together the contract stuff. One question I have is, have you solicited any external review, from any other stakeholders who are not within Metro Legal on this contract language?
Pretty much. Derek can weigh in on that too, but we did over the past week to 10 days or so, as we've developed and drafted this, given them opportunity to redline and add some comments in here and clarifications, and this is a summary of that.
Yeah, sorry, maybe my question was not clear, but did we ask other people, even stakeholders in the community, what they perceive to be some of the issues that, are currently exist with the contract so that we can improve on them? Or is this just sort of ideas that you had or that Metro Legal had?
No, this has been internal with finance and procurement, Ava's team, and our contract administrators, including Metro Legal. Again, it's taking our existing contract word language and tweaking it, consolidating the safety terms that are in multiple places in our contracts today and adding the safety platform.
And the proposed definition of construction contract, is that something that so I have the contracts actually right here because I reviewed them, but is that in addition that you plan to add to the actual main text of the contract? Because I understand the other thing is just kind of an exhibit attachment to the contract.
Yeah, the safety language itself will be a clause in our contract. It'll be numerated as a, section or a separate article in our existing contracts. The definition would be of a contract would be in the terminology section of a contract where you outline the terms and things of that nature and define what certain words are as you develop these contracts. Will be at the index, if you will, unless Dennis can or Ava can clarify where that will be housed.
This?
Yeah.
Let me just hold my legal again. Definition of construction for construction compliance board purposes is to define where your role ends and begins for construction contract oversight. Construction contracts under the authority of the procurement agent are, I think, contained within this, but we don't put a definition of construction in a construction contract.
Right, understood. I mean, obviously, one doesn't currently exist, and my question was just, is this being added to the text of the contract?
Not the definition of a construction contract.
So then where does this go? Where does this live?
This is to define for your purposes what your role is in terms of construction compliance board overview. There's been continuing questions about what is a construction contract. So this is assembling state law provisions, the types of activities that Metro conducts with relation to public facility projects, and it was an effort to kind of encompass that so that you all would have a framework of what you're likely to see in terms of your authority and jurisdiction over construction contracts. The language, as I understood it, for the safety language requirements, that's one of the assigned responsibilities under the ordinance council adopted for you all to propose language to be adopted and incorporated into construction contracts going forward. So it will be incorporated into a construction contract, but a construction contract in and of itself, as they're procured through solicitations, that's going to be the purchasing agent's authority. He or she determines which ones are in their construction contract portfolio versus which ones may be in another. But no, we did not recommend as a legal, and I don't think it's in the purview of the board to define what's a construction contract for the purposes of inclusion in a construction contract.
So just to be very clear, this is just, even though it says proposed definition, it's strictly informative for us.
Correct.
Okay.
And for the staff.
Understood.
So
It's
that-
not legally binding. It's your summary of the statute. The statute, is that fair to say?
Yeah, I mean, it's going to be amenable to changes in the law, but it's so that we have you all have a framework to know, and the staff knows, what are they supposed to be reviewing? I guess I could illustrate it. For example, there may be some maintenance contracts that involve installing glass panes in windows. But that's going to be under your purview under this definition because it was thought safety is important regardless of who's or how many are up on a scaffold or whatever. And some of them are fast-moving projects. There are IDIQ contracts, for example, that involve a lot of those maintenance items. But what is to not be included are things like the internal janitorial waste collection and things like that. Those are maintenance contracts, but not necessarily construction contracts. That was my understanding in the framework. Nothing in the ordinance required that the contract language itself be modified to incorporate a definition of construction contracts. This is just being a guide to help everyone know what we're working with, whether it's procurement, the staff, this board, and the legal advice that we're going to render about what you do have a role in, developing safety programs and things of that nature that could come up during the implementation and effectuation of a construction contract. So that's the best I can explain it, but the safety language requirement is the one that I believe was being alluded to is the one that requires your action in order to meet your deadline for council recommendation.
So the deadline is for us to make a recommendation to the council on what should be our responsibility when it comes to contracts.
No, on what you're recommending for safety language for Metro's construction contracts going forward. That was what your, and it was originally to have been done, and we've got it extended, but it's limited to the safety compliance component, and I believe.
Okay,
the-
hold on. You just told us that what we are discussing is what we are going to take on as a board. That's what we're discussing. What do we feel that we should be dealing with? I think I'm just trying to.
Yeah, that's where you all will weigh in on what is a construction contract for your board purposes.
Okay.
But that
then-
doesn't get incorporated into the contract itself.
Right, but after we agree on something, that's going to go to the Metro Council? you
No,
said?
no. You have been given authority under the ordinance to consider construction contracts. You have
Yeah.
purview over those.
So what is the deadline we are talking about?
There is not a deadline on that component.
Or what's the deadline about? You said we have a deadline.
The safety language
Okay,
recommendation to council that would affect contracts going forward.
okay, can we focus on that?
Certainly, but I was trying to answer his question, which was whether or not the definition of construction contract is for purposes of recommending to council to be included in contracts going forward. That's not its purpose.
So, Mr. Chairman, if I, after, the page after the Hub Nashville deal outlines what we have to recommend to council in more detail, if you want to look at that.
Okay.
Again, these outlines
Before
of
I do
functions.
that, did you get your question answered?
Yeah.
Okay, sorry. I got confused. I thought we were just talking about the same thing. All right. So, yeah.
I
please.
misspoke on the term definition of contract. Derek corrected us on that. I stand corrected. But the page that starts after the Hub Nashville page, this is the functions that are outlined for the board in our bylaws of what we recommend to council. So again, it goes down. I've listed that functions. Again, provide recommendations for the scope of safety plans for construction project procurement. The recommendations are describing the types and size of projects, whether safety plans should be required as a part of the procurement process, and any other relevant issues related to safety plans. So my description and my recommendations are listed below here. I know our procurement team and contract team probably has some weigh-ins on dollar amounts, size of projects, and things of that nature. And I know Ava probably or Dennis might want to speak to that as well. But then again, this is one of the recommendations for council from this board. And then the next page gets involved into our pay application process. And again, I've made some notes there on not any recommendations in that regard right now. But those are the three questions that need to be answered by this board and or for the recommendations that we'll draft to council.
And after we make these recommendations, the council may adopt them?
We'll get it back to whatever information and red lines and comments that this board has. We'll get back to legal and Derek and Matthew to draft that in the appropriate format to submit to council.
Can I ask a question? Is there a reason we're limiting just to safety? Like safety requirements as opposed to other aspects?
I'm sorry, Michael, you said omitting safety?
No, we're limiting.
Limiting?
This is only concerning itself with safety.
Yes, the only two recommendations from this board that are described in the functions for the recommendations to council is having to do with anything with our payment application process and the safety plans. And again, this safety language is what we're recommending. Further, again, do we need to establish any types and size of projects, whether they should be a part of the procurement process or any other items that are relevant to safety plans on that page? Staff, if you will, or have outlined those recommendations here below on those two pages. If there's any other comments or red lines that you guys want to add to that or make more clarifications on it, we can.
So if I can ask another question. So let's say we follow just what it's here. We can make recommendations at any other time. There is no limitations of us reaching out to the Metro Council with a recommendation, right? It doesn't have to be just this one time.
I'd have to take a second look, but I know you are under a one-time deadline to make recommendations. I will get back to you to see what your future recommendations are and what limits they may have. I'm not aware of it prohibiting them. I will tell you that.
I'm just trying to put him at ease that if he or the board chooses to make additional recommendations in the future, that we can do it as well.
May I
So if
answer
you
it this?
can-
Yeah, may I answer? I don't think you making these recommendations is going to affect whether you have the right to in the future or not. This is a mandated obligation, and I would recommend you meet it first, and then if you have others, we can always take a look then. But I don't think the act of making your first required recommendations precludes future ones.
That's what I was trying to clarify.
Sure.
Yes, Councilman.
Thank you, Chair. All right. We'll start with the safety requirements. All right. I have a couple of recommendations. So going into number 1, the general safety obligations.
Can you tell us the page that you are?
Yes, I'm in, sorry, I had the other one.
I'll
So
try and number these next time.
So
Councilmember.
in the contract safety language requirements, if you go into number 1, it says general safety obligations. If you look at 1.2,
Yeah.
it says, well, I'll start at 1.1. 1.1, contractor shall perform work so that no laborer, mechanic, or other person is required to work in conditions that are unsanitary, hazardous, or dangerous to the health or safety as determined under the applicable OSHA and TOSHA construction safety standards. Are there any other safety federal agencies that should be added in there, right? Because those are 2 federal agencies. I think that we should consider other federal agencies, right? Because technically by state law, we cannot require anything other than what is technically already required by either the state or the federal government. So that, I think, would include the NLRB and potentially other federal agencies, correct? So can we add other federal agencies?
I'm not sure, but if you have some, like, what is the NLRB?
National
The-
Labor Relations Board.
Okay.
I'm not sure they have purview over safety, but that would have to be, it could offer that, but I don't know that they're not, I don't know that they have oversight over OSHA, in other words. OSHA is the safety mechanism under federal law.
Yeah, but looking at the contract and compliance board functions, I look at our purview, right? So I'm looking at our bylaws and but the legislation overall, and it says we review construction sites, we review payment, we review best practices, and I consider them as a best practice.
I can't tell you that tonight. I haven't
Okay.
looked at NLRB jurisdiction and if it even has rules for construction projects. I just don't know.
Okay. Not just them, they're just an example, but best practices overall for other federal agencies and which other ones could be added under section 1.1. Then under section 1.2, the last sentence, it goes, contractor is solely responsible for the safety of its employees, subcontractors, suppliers, and other persons affected by its operations. If a sub or a sub of a sub violates a standard, is the contractor with the general contractor terminated? That is a question for procurement, I guess.
I think it would be based on whatever the occurrence. I think it would be based upon whatever the occurrence is.
Okay.
In other words, after the investigation of the occurrence.
Okay. Because I think it would be a good idea to have a process in which potentially, depending on whatever it looks like, if there is a policy in which we have, do we have I guess, first question, do we have a policy in which general contractors have to submit approval for their subcontractors?
So that's usually lined out in the RFP process.
Okay.
So in other words, and David, correct me if I'm wrong, they will list out who they plan to use as their subs.
And can we disapprove a subcontractor?
Absolutely.
Okay. Can we create a process in which, if there is gross negligence, that we can bar a general contractor from having subcontractors in the future?
My assumption would be that's possible.
Yeah, because I don't want this to be something that affects all general contractors. I think this should be something that's used sparingly, just when it is a problem, right? And ideally, if it is a general contractor that has had several issues, we wouldn't use them in the future. But having the state law be what it is, we could only bar a general contractor for 3 years at the most, correct?
That's correct.
Yeah.
There's also a suspension. You can actually suspend as well. Mm-hmm. But the way that I look at that is, like, Ava's my customer, and so if she hears something in her contract management process that there's an issue related to that supplier, usually she'll contact us to get involved in it, and then ultimately, with Trey being another level, you know, my expectation is that Trey would be investigating that along with Ava before you actually come to procurement, right? That would be my assumption.
No.
We would provide all supporting documents.
Yeah.
No.
Oh, I'm sorry. Yeah, so this situation has not ever happened before. Like, we have several contractors, but it has never happened before. And yes, the general contractor present to us the list of subcontractors and everything, so we know in advance whom we are dealing with. But let's say that there is an issue from one of our subcontractors. Definitely, we would request documentation, what exactly has happened, reports, something. And we collect all the information, and we have the right to ask the general contractor immediately to eliminate that subcontractor. And for the next step, to bar this subcontractor, I would collect all the necessary documentation and then submit to the purchasing agent and ask him that this is the evidence and this is what happened, and I am requesting to bar this subcontractor from any work related to Metro.
Well, it hasn't happened under your department.
Yes.
But we are about to take on MMPS, where we have had issues, and we've just had a sub of a sub where we had a fatality, right? And we have had issues of wage stuff. So it might be something that we should probably consider as a recommendation overall. Something to consider, right? What can we do to prevent, bad actors from being able to take advantage of our system?
Councilmember, can I, do you have many more items?
Got 2 more.
2 more? What I was going to suggest, if there is a list of items, that instead of engaging in a dialogue, just give a list of items that we want Trey to follow up with, because there is a packed agenda, and I just want to be expeditious. But if it's only 2 more, knock yourself out.
Yeah, I'll give it, since our deadline for this is January. All right. Okay, and so under number 2, safety plan 2.3, I think that the plan should be displayed on a site and available online. And then under number 3, job site protection, maybe this doesn't need to be a part of it, but I do know that there's a noise ordinance. I don't know if that needs to be a part of this safety requirement, and it probably doesn't, but that's just a question overall.
Yeah, from my experience, the noise ordinance is a document that the GCs sign at permitting that they adhere to, but it's part of the permit process. And they do acknowledge and sign that document with the codes office.
Yeah.
Permits outline work hours in the noise ordinance is a separate document.
In addition to that, we always include some kind of language in the scope of work in the RFP when we publish related to disruption or any noise or anything. We include some language in RFP as a requirement.
Does anybody else have any comments?
Okay, thanks for compiling this. I think it's pretty comprehensive and like really well thought out. My question is about Section 8, which details the safety platform and the requirement to use the safety platform to report. And then if you go down to 8.5, there's oh wait, sorry, is that it? Yes, there's like a list of, you know, remedies that Metro can take for failing to use this platform. But I don't see any like list of remedies that Metro can take for like not complying with any of the other bullet points here. And so I'm wondering if that needs to be pulled out and made its own section, because the way I read it, only these remedies only, maybe I'm reading it wrong, but failure to comply with this requirement, which the way I'm reading it refers back to just using or not using the safety platform rather than like adhering to the whole rest of this safety. Does that make sense?
I can go back and take a look at the wording and rely on our legal department a little bit too. Again, when we initially were looking into this safety platform, we were all excited about the possibility of the GCs actually using it and then be a part of, you know, users for this platform. Unfortunately, it's not going to be the case. However, with this being just a tool for Metro employees, safety coordinators, and staff like myself doing those inspections, all those trades will be a part of the platform as a responsible party. In other words, when we do inspections, it allows us to distribute those reports to them, answer to any issues and things of that nature. For example, if we continue to see a particular issue with a sub, okay, you know, this is the third time, 3 strikes, you're out, right?
Sure.
They fail to wear a hard hat or whatever the infraction might be. These are the remedies that would come about on Metro's behalf towards that particular GC. Again, the platform, we're able to do these inspections, and if we look at 25, 50, 100 items, it scores them, so we can, again, slice and dice all those inspections with all that type of information, and it allows us to look at, okay, across multiple projects, across multiple GCs, what's our number one infraction that we're seeing based on those inspections. If we see one particular trade that is, you know, guilty of certain things, then that's what these remedies are. If they don't resolve those problems, things that we can enact and hold them accountable to.
Excuse me. I think she wants you to draft something that addresses her comment and bring it back at the next meeting, right?
Well, I don't know. I don't know if I'm reading this correctly. Do you want to weigh? Do you want to weigh in?
Yeah, I think the contract already has typical breach of contract provisions.
Okay.
I think the intent here, and it can be made more clear if you'll listen to this option. This noncompliance and remedies is regarding this safety platform, Section 8 of the contract, and should be implemented because 2 days to cure may not be sufficient for other types of breaches, but I believe the belief is for failing to use the safety programs, what's it called, the safety platform, that's remediable in a fairly 2-day confines, or else you start going through these. So to correct it, I think that first sentence, and by the way, I think there's a section numbering or subsection. 8.4 should be 8.3, 8.5 should be 8.4. And then after written notice, 48 hours to cure, failure to comply with Section 8's requirements may result in the following actions. Mm-hmm. Then that would not disturb the other breach of contract sections that are already there and in place.
Got it.
Does that answer your question?
Yes. So that was my question, is whether the remedies only were under Section 8. So like, what would the remedy be for if someone violated Section 6, for example? And do we need to list a remedy for noncompliance with any of these other sections?
Well, again, I believe the thought was the standard contract breach provisions they have their own mechanisms.
Okay.
Some of these things like failure to adhere to the safety plan, it may be curable in a quick fashion, but it may be something that requires a little more thought than just the mere 48 hours. Get in gear and get your computer geared up with our safety plan program requirements. But some of these others, the thought is that triggers the usual provisions in the contract about breach, giving notice, rights to cure. There may be some language in the breach provision that even says that the contract could be terminated immediately.
Great.
But if they just aren't using the software correctly,
Great.
the thought is you get a couple of days grace to get up to speed.
Cool, I understand. Can we get a copy of the breach of contract remedy, like the stuff that's not included in, just in this language, but the general? Okay. Yeah.
Whenever there is any breach to the contract, first the department discuss that and give notice to the contractor, and then if the issue has not been resolved, we escalate to the purchasing agent and provide all evidences, and that would probably end up by terminating the contract.
Cool. Yeah, I would just like to take
Yeah.
a look at it, just to know if somebody violates this, like
I
what
will
the
give it to
process
Trey.
is.
Yeah.
Awesome, thank you.
Thank you.
And then my second question, I think you sort of touched on this, Sandra, but, and I don't remember what department this man was. He came to present to us, and he had the presentation with the dogs in it. I think it was from procurement. Yes, okay. So, also, this is not a technical term, but he said that there is basically like a naughty list. Like if you are in breach of a contract, you're put on the naughty list for 3 years. What is it called? Debarment, yes. So I would love to see included in our safety language one of the remedies for failing to adhere to this safety language is you will be placed on the debarment list for 3 years. So I would love to include that in this language. That's all.
Thank you. If I may add to that, I'd be curious to know if we have provisions to prevent somebody from changing the name of the company to something else and trying to get a contract. And you don't have to answer me. It's just something that, as we do that, to make sure that it has teeth to prevent people from not falling into another company. I mean, if somebody's dangerous to people, we don't really want to have anything to do with it. Thanks. Your turn.
Thank you. I have one question and one suggestion, and I'll start with my question. And I'm not sure who's best to answer this, but has there ever been a circumstance where a contractor has had a sub on the site but hasn't disclosed that sub to Metro?
No, it never happened, because definitely with each job, we are well aware of the prime contractor and all the subcontractors working on site.
And that includes like the subs of subs?
Basically speaking, all the workers, yes.
Okay, so like anyone who's on a Metro job site,
Yes.
we should know. And is that an ongoing process? Like, let's say contractor determines they need to get another sub to do something else. Are they obligated to come to you, report that, get your approval before entering that contract?
Yes, because all that is linked to MNPD background check. We don't allow any worker on site without having to pass the MNPD background check. And that's why whenever any prime contractor hires a subcontractor or he has a new employee, he has to notify the department or the project manager in order to pass the MNPD background check. And normally we give them like a card, access card, so they can access the site.
Got it.
Can I add to that?
Yes,
So in addition to that, the Business Assistance Office, which also presented to us, they have a commitment, the supplier has a commitment on hitting the numbers for, basically MBE, SBE, and that sort of thing, right? And so this is listed. Well, then when Trey mentions in this that they've audited these contracts, they're actually auditing those exact suppliers. right? So if they had somebody different, it would immediately be called.
And in that circumstance, would the sub be let's just call them the sub that's not supposed to be there? Would they be asked to leave, or how? Like, what would the recourse be in that circumstance?
So it's interesting. I'm sure that would be the case, but I'm with Ava. I've been here 2 years. I've never seen that yet, right? But I'm sure at some point in time it's happened, but I'm not sure what the remedy was for that. But
Got it. Okay, because I think my concern, and this to segue into my suggestion, from my experience and from what I've heard and seen, is there's always a question of like who's responsible. I think we had this conversation at the last meeting where there were, I think we're kind of all in agreement. Well, the prime should be the person who's responsible for their site. And so I think the way I look at this is I want to make sure that it's very clear that that point is clear, that the prime is responsible for anyone on that job site, whether they are a Metro approved sub or not. Because, I mean, heaven forbid, that may happen at some point where someone unauthorized is on the job site. And I think that this is addressed in part in section 1.2. The last sentence says contractor is solely responsible for the safety of its employees, subcontractors, sub-tier trades, suppliers, and any other persons affected by its operations. But I think we can make that a little clearer, particularly like responsible for what? What does the safety mean? Like the safety as it's defined in this edition, OSHA, what? And so I think that's, I'm happy to propose some language, and I could do that offline, not to, waste everyone's time. But I just wanted to make that clear. That's my concern. My suggestion would be to make that language a little clearer to show that that's who's responsible.
Thanks. Do you have any comments?
Just to echo what my kind of fellow board members have said, I would like to see, and again, just having been here for 2 days, this isn't something that I've had access to yet. But I would like to see this kind of where it would fit in the context of the full contract to understand, because I think my main question was what are the enforcement provisions of this? And it sounds like, of course, that's in the main contract. So I would like to review the full contract so I can understand this in context, and then I think I'll have some more comments.
How about you?
I think from my perspective, Michael, on what you mentioned, I think that terminology is in the bigger agreement. So I think that would solve a lot of the questions that we have on this.
Thanks.
We can get a copy of a base template to the team for review.
Thanks. I do have a comment that in my experience, having been in the Metro Council before, I saw that lack of interpretation or communication in different languages creates unsafe conditions for people working on Metro sites. And so if we, on Section 6, when we provide site-specific safety programs or when we are communicating with the employees, I think it's important that we have information that can be fully understood. I want to remind people that, the type of English you need to order a burger is different than to wear a safety vest properly. And so there are different levels of English proficiency that if we don't have something that is clearly understood by people, we may have unsafe conditions. So I will include language there to make sure that it is language proficiency, language accommodations. All right. Well, thanks everybody for the feedback.
I'm so sorry, Mr. Chair. I propose that something new be added into this. I don't know if we should, if I should make a motion and we should pass that. I don't know it wasn't like a friendly suggestion. I really do want the debarment to be added as a remedy for failing to
Let me
comply.
ask the lawyer.
Thank you.
Due to the deadline, what is that deadline in January? I need to think through what your question is, because you guys need, I think, to take a vote tonight, and you need to settle on some acceptable language on some of this stuff. So I've taken notes. I think Trey has too. So I may have some proposed language even to your language accommodations and barrier situations. I will rely on you, though, to help me use the correct terminology, but I've noted that for inclusion in Part 6. Your debarment remedy could be a bullet point at the end of Section 8.5 as a potential remedy as well. I would not recommend we limit it to just 3 years. That may be in some instances or others. In other words, I think it should be general debarment. I'll give you my legal rationale. You can question it all you want, but they need to make a decision tonight under the deadline, I believe.
So somebody should make a motion that includes a lot of the language that was discussed here tonight?
Correct, but I'm trying to wordsmith as I've heard these thoughts and keep up as they kept popping out. So it may take a moment.
I think I've got those, but
Chair.
Councilmember.
So our first meeting in January for council has actually been canceled from here on out. And so we only have the second meeting in January, which is the 20th something, which we moved our recommendation to be submitted by the January meeting to council. So I think that gives us a little bit of time. And so our board is also asking for the entire contract to have some more recommendations submitted. So perhaps in my suggestion, if we could get the first draft sent to us with the recommendations we have made included, and then our meeting in January should be when?
I think that's that fourth Tuesday in the month, right? And our meeting would be the fourth Thursday moving forward next year.
So unless we have a special meeting in January, then I don't know if we would have those recommendations implemented with new recommendations made with extra contract language. But just as an FYI, our council meeting will be 20-something.
I guess I could propose that we move the January meeting to the third week of January. Would that give us time?
It's showing on the schedule right now the 27th, which would be the fourth Tuesday.
Okay.
That's a week after the council meetings, which are the first and third Tuesdays to accommodate council members.
So I propose that we move the meeting in January to the Thursday before the council meeting. That way we have the time to evaluate this and vote on it. Is that okay for everybody?
Everything sounds legally solid, what you're talking about. Just to let you all know, though, your deadline is to submit the recommendations. Metro Council doesn't necessarily have to vote on them at that January meeting. So I'm a little concerned as the lawyer because we got to meet all these filing and late filing deadlines. As long as I have a final product to put together with a resolution.
That makes sense.
So, yeah, your plan of a special called meeting the third Thursday before Metro Council's.
It's not necessary because we just need to file it. We don't have to file it so they can discuss it.
Well, but you do need to have your special called meeting for me to get it filed as a recommendation from this body. So you were in the right track totally. I just wanted you all to understand it would be late filed beyond agenda notice requirements, even if you had your special called meeting. So I think you're meeting your obligation just getting the recommendation to legal so we can put the legislation with it.
So I don't need to call for a vote to change the day of the meeting, right?
I don't think so, but that third.
Okay. And nobody seems to have a problem. So please move the meeting to the Thursday before the council meeting.
That would be the 15th, Thursday the 15th.
Okay? And we have time to advertise it and everything. And you guys are all okay with it?
Could we do it at 6 o'clock, not 5 o'clock?
I was going to recommend Michael do to just, everybody else has jobs too, right, to move to 5:30 or 6 so transit time can help everyone out.
That would be very helpful.
We can do that. 6?
Yeah, I just want to note I'm out of town all that week for work, so I won't be here.
Will we have quorum?
I'll be here.
All right. Well, so please do. Okay. Thanks. We'll make fun of you that you're not here. All right. What's next on the agenda?
KPI review and evaluation criteria, again, initial start of that just for Eric and Julie with our partnerships to introduce that. I don't think there'd probably be a whole lot of dialogue on that tonight or finalizing anything. We just wanted them to be a part of this process as a impartial judge or jury, if you will, to introduce you guys to that part of the program, which will result in be future discussions on our next meetings.
Okay, so we are ready to introduce them. Can you do it for the people who are watching on TV?
Yep. So Eric Mendoza and Julie are part of our partnerships, our consulting firm that has been working with us and myself on all of the topics and subjects that we've covered to date, and invited them in again to meet everyone and to lead us in the KPI discussion for what the board criteria is for this role, and as well as my evaluation for this role. And that documentation is a part of your package information too. But I know Eric and Julie both have several questions that they want to ask as we continue to draft and move into this part of some of the things that we need to cover.
Thanks.
Yeah, so thank you for the introduction and for having us. So we did make the recommendations for the KPI, so you have a copy of it. So generally, just we started off with the responsibilities of the role, right? So the creation of the board and also the walking through any of the members that are either were added recently and understanding what is the board's mission and also kind of what the oversight of you all are going to be doing, for example, as the definition that was created for you all, so you all understand what the contract language is that you're going to be overseeing. And then just any of the big portion of it that we also saw was just the coordination between the different stakeholders that are working with this board, with the different departments, and making sure that executive directors is creating those relationships, right, and making them understand what the board is trying to accomplish in line with, again, legal, but also as well as making sure everybody kind of plays their part as well as you all are working with the different agencies, and that being your middleman of the communication. Then we go on to I can go from there, but anybody has any questions with the responsibility section that we would like to open up?
Does anybody have any questions? No questions.
No questions. Okay. For the core competencies, it was pretty much on again, a very communication and adaptability, because there is a lot of moving parts in this role, and understanding that they have to be flexible in working with your schedules and again, the different schedules with the different departments, and making sure they're taking that customer relationship and serious, and also kind of that dependability in working with the different peer relations and different teamwork, especially as a group with you all for the director role, and how they're interacting with the different agencies and what you all are hearing from your different agencies as they are working in this role, and whether or not they're actually communicating well enough the mission that you all are working towards. So we thought that would be the best of the core competencies as a measurement of success for this role. And again, in kind of the expectations of being here, of attendance, making sure they're being compliant with any of the rules that you have set forward, and following those, and making sure that the work is actually being done in a timely fashion when it comes to any of the recommendations that submitted to you all are getting backed. And feedback is also, and that includes even working with outside partners like ourselves when we are presenting and submitting ideas and recommendations to you all? Are they passing it on to you all, and then giving that feedback to us as well of what you all are saying, and making sure that we can work with you all in answering any questions that you have, as well as concerns that may be brought up by legal as well.
Any comments, questions?
I actually like this particular portion because I think it's going to be important for Trey to be very visible in the community. And I know since he's been here, he's interviewed, I'm going to say hundreds of people at this point. So I think his position, not only within Metro, but then also out in the community, is going to be very important. So I like this that you added. So.
Thank you. All right.
And then lastly was the goals, right? So I know a lot of it has been trying to get those KPIs into place of what you all want to track and see as a board, be those metrics in seeing that success. So I think that's the biggest thing that would influence a lot of these goals overall at the end, once those KPIs are actually kind of agreed upon and established as a board, and whether or not that they're also kind of implementing that compliance piece and oversight on making sure that when they are working with the different departments, they are getting back that information of those track metrics, and then presenting that back to you all is the biggest thing. And then again, that stakeholder onboarding and communication between anybody that's new to the board, but also that may be new to any other department, so they understand the success rates that you are working towards, and whether or not those goals are being met or not, right? Based on what you're tracking that you all decide as the final KPIs that we have also sent for recommendation.
Thank you. I have a question for the committee. Are there any of these recommendations that need to be expanded? Do we need any more rows? Any of the descriptions need to be adjusted? Council member?
Thank you, Chair. This is great. Thank you so much for putting this together. I do want to add one thing to it. I think at the last meeting, you all should have received just some historical context as to how the legislation and the board came about. And Emma, you didn't receive that, but one of the things that we had envisioned for the executive director was for the executive director to have an expansive OSHA training, so that they might be able to train up the future inspectors and be able to recertify them. So, and that personally, that was a vision that many of the architects of this board had, right? And so OSHA 500 was something that we had envisioned that they would receive certification in and be able to be an instructor and have that live within house of Metro. So we wouldn't have to pay an instructor and save ourselves a little bit of money. So I guess it's a question for the board, right? If we would like our executive director to be OSHA 500 certified, then that would be a responsibility that we would give our executive director, looking forward into the future for when we have our inspectors brought on board, so that they might be able to be recertified in the future and taught by our executive director. And that's a question I pose to you all. Is that a responsibility that we want to add in there?
Before we answer the question, I wanted to ask our lawyer if there is any liability on having and one of our employees provide trainings on OSHA to other employees.
Let me ask you, do we have a IDIQ contract or anything in place?
Microphone.
And I'm not putting you on the spot, I know you may have to research it. We may have some contract obligation that I wouldn't want to supersede by us. You know, I just don't know if there's a contractual obligation within Metro for TOSHA training and/or certifications, because that could put us at odds with a vendor that we've agreed to procure those, that we've procured those services through. Absent that, it couldn't, hey, the government takes risk anytime it legislates or adopts something. So if that's a financial risk that Metro is willing to obligate itself instead of under a contract obligating a trainer to protect us if they provided wrongful training, that's a different issue. But just having TOSHA 500 requirements and then training our own employees, if TOSHA permits it, that's another thing that I need to check on. I don't know if it's supposed to be independent of our entity or not. I'm not saying it is or isn't. So I just can't finally answer you, but it can involve risk. But our government doesn't allow risk to make its decisions typically.
Yeah, I like the idea. I just want to make sure that we can do it.
Yeah. And I'll give some more thought to it and check with, the legal director directs me, obviously, and I'd like a chance to speak with him, but my initial thoughts are I wouldn't want to violate an existing contract that we have that requires that they be our source for training for TOSHA issues. And second,
Sorry, even if for whatever reason we cannot provide the training, you're suggesting that it's a good idea for our director to have that training.
Yes, I mean, our executive director should be an expert, right? And as they send out inspectors onto these sites, we need to know what we're looking for, right? It's not the only thing that we're looking out for on our sites, right? We're also, auditing our contracts, et cetera. But I think it would be important. I know that our executive director has OSHA 30.
Yeah, I've got OSHA 30, and I've actually had plans to attain that 500 or what's a 510 designation. First quarter here next year was on the calendar.
Okay.
But what we do with it, maybe something we'll clarify.
and let's wait, one other comment. The job posting may or may not have included that requirement, and to modify it now may have to go back to the Civil Service Board to adopt that as a requirement within the job description. So there's a lot of moving parts to add something like that.
Well, but if we want to make, Trey, it's not about you, it's about the role. And so if we want that role to include that, then we can actually make it part of what we are aspiring to do. And it may not be something we can do now, that it will take some time, but it's something that is important to the board. Then, sorry, I'm putting words on your mouth. Do we need to make a motion, or we just make a recommendation, or how will it work? I didn't ask any comments to her recommendation. Sorry, I'm just taking over the whole thing.
Can I ask a question
Yeah.
of the executive director? Do you conduct all the site inspections yourself, or is it with a team that sometimes a team member goes, or?
I'm currently doing them myself.
Okay.
In a bigger context, though, depending on the size of our projects and our GCs, they do have safety directors and coordinators on project sites that do weekly, if not daily, inspections with their internal systems as well. There's very many different type of safety platforms utilized in the industry. For example, Bell Construction uses a program called HammerTech. There's quite a few of them out there. We vetted over 13, 14 different programs before we landed on the one that we're going to use internally. Again, we're bringing on the other departments like Metro Water and schools that'll be able to utilize that platform as well. currently Metro Airport Authority uses the same program. So as we expand this particular platform Metro-wide, we'll be able to add other users and train people in what we use it for. But that doesn't eliminate the requirement for GCs and the subs to have those trained personnel on site and conduct their own inspections as a general rule, because a lot of the big GCs do that anyway. Some of our GCs also use a third-party consultant to come in and do an impartial survey. There's several of them here in Nashville, notable Fortier. There's another one called Division 1. They actually use the safetyreports.com platform for doing their third-party inspections as well. So it depends on the trade and how they handle their safety platforms. And again, if we have one that doesn't have that, we're filling in that gap. But yes, to answer your question, I do all the inspections right now. And from a volume standpoint, with us only having 2 to at most 8 projects right now, it's still a one-man show. It's not a whole lot of site inspections when you only have 8 projects for a staff to handle those type inspections.
Okay.
Currently.
Thank you.
Okay, so Councilmember Sepulveda made a suggestion. We heard from our new board member. Any other comments? Yeah, please do.
So OSHA 500, I just wanted to make it clear. The OSHA 500 is, what it actually is a trainer course in OSHA for the OSHA standards of construction. It authorizes a person who has the OSHA 500 to be able to teach the 10-hour and the 30-hour and to be able to give out those cards. It does not make somebody OSHA compliant or compliant, yes, OSHA certified, and it does not qualify somebody to enforce OSHA, and it does not replace a safety manager or a competent person for, inspections or any other kind of investigations. It does not satisfy the OSHA compliance requirements by itself. So OSHA 500 and OSHA 501 are both those courses that they take so that they could teach the class and issue cards for OSHA, but it does not negate. You would still probably have to have somebody else that would do the inspections or an OSHA type of inspection, but at least you would have somebody on site to be able to give, construction workers or contractor workers, anybody else, their OSHA 10 card and their OSHA 30 card.
Thank you. So what does the committee want to do? Any comments, any suggestions? Well, I guess we want to hear more about it. I mean, I asked you some questions before, so if you can let us know at the next meeting. When is this evaluation matrix going to be implemented?
Again, we extended additional 6 months for my evaluation criteria for the Civil Service Commission. I mean, personally, I'd like to get that done maybe by March, so we can get that put to bed.
This is my understanding is the probationary period was extended 6 months so that he could be given what he's going to be evaluated during that 6-month probationary period. My concern with adding an OSHA 500 level of training now may violate what was in the job description and the job requirements. Not saying you can't do it going forward, but I don't know if it would be fair to implement it and possibly result in him not being qualified as he's to be judged as of where the status is now. That's my general opinion. Okay. I don't mean at all that it's not something to be evaluated, but I think, and I don't recall now, how far are we into your extended 6-month probationary period, which answers your question, how much time do you have to get him aware of what you're going to be judging him on so you can recommend or not?
I guess we have 2 different things here. One is when it comes to evaluating his performance. And the other one is, in general, what are we going to do with any employee that we hire for that role? As a board, we need to have a clear idea of what we are proposing to do. So I think even if it's not something that will be applied this month or this session, I think it's an important consideration that we need to look at. So there's like two things that are going in parallel, and that's why I still would like to hear from you on looking into that. And then the board will have to decide if they want to use it or not.
Yeah, Chair, what I might suggest is that, I mean, Trey has said that he's planning to take the OSHA 500 class, so like, that's already in your plans, that's awesome. Voluntarily without having it in, you know, the KPIs or whatever. What I would suggest the board look at then is if the job was vacant, then we add that into the job requirements for any future executive directors. But it feels like what we want to happen is happening, and we might not need to add it into the KPI.
Okay.
Chair, can I make a comment also? So if I recall the job description, we were going after someone with a lot of experience, right? A broad base of construction. Trey, you've got procurement background, you've got a lot of background. And so from my perspective, I look at this as being sort of like a football team. Well, we hired the coach. And so for me, when we hire the players, you want a quarterback, you want a running back. And so for me, I think that's where we could get into the specifics of what level we want that. But Trey needs to have a good understanding of it, which I think he does. And so I think that's where I'm parked at right now, not necessarily him being the one that's got to have all this high level of OSHA requirement, but then making sure that he's got a broad background, which he does, and then hiring the people that have that, whatever level we decide on. I think that would be my comment.
Yeah, and Chair, just an additional comment too, again, for what we do today, the safety platform, you know, doing the inspections and the job site visits and the relationships I currently have, and again, from an experience standpoint, and I appreciate that, Dennis, you know, OSHA 30 designation, most anybody that has that knows how to do what I'm doing that today and can satisfy where we are with this role. Always wanting to improve myself and any other people too on additional training of regardless of what it is related to OSHA, safety, contracting, best practices that are studied on sites, all of that. I'm all about that. But again, to satisfy where we are today, if, you know, from a designation standpoint, it's more than adequate to do what we do today. Just if that gives the board assurance of where we are today with our current inspection process, it's more than adequate right now.
Thank you, Trey.
So, Chair, just for clarification, how much time are we into the extended 6-month period?
It's 1 month. If you look at May 12th is my start date, you know, 6 months after that, I think it was November, if I'm counting right. So an additional month right now.
Okay.
So May 12th of 2026 would be the technical deadline.
So do we need more time to add any additional KPIs, or are we good with adopting this and sending this over to the Civil Service Commission?
That was the question I asked.
I'm good with it.
Do we need to have a motion?
It's listed under new business, so I would recommend you have a motion. Second, call the vote after discussion, and then I guess he will forward his own evaluation criteria to the Civil Service Board.
Okay.
I've already got this filled out and completed, just so you know.
A blank version, I should say.
Okay.
Well, I make the motion that we pass and adopt the employee performance evaluation as submitted.
Well, we have a motion. We are going to vote on yes or no, and also there will be comments. So all in favor say aye. Oh,
I'll
sorry.
second.
Yeah, we need a second.
I'll second.
We have a second. Thank you. All in favor say aye.
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 Against? Okay. Is there any comments or amendments to the motion? All right. So the motion passes. Is there any other issues with you guys? No?
No, nothing else.
Well, thank you so much for putting this together and for your explanation.
Can I ask them a question?
Yes, I guess so.
You guys obviously have done a lot of work here. Have you guys reviewed contracts like the one that we reviewed at this meeting today?
Yes, we have.
Because I think what would be really helpful for us too, is to get some feedback from you, if that's possible, on, potential areas from your expertise, since you guys bring a lot to this. What could be improved, what we can add, that kind of stuff. I'd like to see that at least.
Yeah, that's not an issue. We were actually taking notes as well as during the whole time we all having your discussion, so we can forward those to Trey.
Yeah, that would be great.
So actually, the next item on the agenda was new business. So,
I got excited.
and we already went over the executive director evaluation and KPI criteria. Are there any other new businesses anybody wants to bring up?
Question, sorry. For the next meeting, when we're going to approve the contract language, should we, obviously we have to approve it at the next meeting. Should we email suggestions and stuff like that in the interim, or how do we want to handle that as a group so that we can not waste time at the next meeting?
My advice will be that you email them to Trey without copying anybody, and then he will forward it to the lawyer for review. And then when you bring back the contract, if we need to vote one item, one amendment at a time, and then vote on the final product, we can do it that way.
Right.
But yeah, please send any. I mean, I'd rather you send them that next meeting be, like the headline. So thanks for suggesting that.
Yeah.
And Trey, if you don't mind, let the people that didn't come today know that they can send suggestions as well. Are there any other new businesses? No? All right, well, thank you for making this happen, and thank you everybody else for showing up today. And if there are no new business, I'm going to ask for a motion to adjourn.
Motion to adjourn.
Second.
There's a motion and a second to adjourn. All in favor say aye.
Aye.
Opposed? Meeting adjourned. Thank you, everybody.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.